Ladies and gentlemen, this is the June 18th, 2009 hearing of the Radnor Township Zoning Hearing Board. Before we begin, we have one administrative item. It's a letter dated May 28th, 2009 to Mr. Robert Loper from F. Harry Speece, Jr. regarding Montgomery Del Valle Associates LP, appeal number 2717, 313 Conestoga Road, Wayne, PA. Dear Bob, I write to you as a representative of Montgomery Del Valle Associates LP, owners of 313 Conestoga Road, Wayne, and request a 6-month extension of time for the owner to secure a building permit for construction of a proposed dwelling and garage. The Zoning Hearing Board granted relief from side yard requirements and approved construction of the dwelling and garage on this property, which previously contained a non-conforming dwelling, which was destroyed by fire. Most recently, the board at its December 2008 meeting granted a 6-month extension of time, and a similar request is made at this time due to the adverse economic conditions in the real estate and construction businesses, which makes it difficult to proceed with the construction of a single-family home and garage on this site. One of the partners or representatives of Montgomery Del Valle Associates LP will be present at the Zoning Hearing Board meeting scheduled for June 18, 2009. Should you have any questions concerning this request, please do not hesitate to contact the undersigned. Is there a representative of Montgomery Del Valle? Sir, if you'd come up and identify yourself.
Jeff Pendergast.
And can you just is there anything you'd like to add to what's been set forth in Mr. Speece's letter?
Basically the economy, we are fully intend on building a house on the lot, and the way the building business has gone in the last 8, 10, 12 months, it's been very difficult to do that, particularly on a spec home basis.
Okay. Any members of the board have any comments or questions for Mr. Pendergast? No. Did anybody have any objection to the request of 6 months? No. Peter, you all right? Okay, 6 months.
Thank you very much.
The first matter we'll consider this evening is appeal number 2815, Paul Bloomfield, RA, for owner Pam Hay, director, Mainline Montessori School, property located at 459 Sproul Road, Villanova, PA, zoned R1 and in Ward 4. Applicant seeks relief from strict enforcement of riparian buffer as determined by the township engineer for purposes of extending driveway to new location for parking. Applicant seeks a special exception from section 280, 89.7 boundary determination.
Okay, before Mr. Chairman, last in this appeal, at our last hearing, we received an unsigned email from Mr. Jim Schneller indicating opposition to this application. We declined to accept it. The board will not accept unsigned emails for anything because they may not be authentic. The email has been printed out and is now signed, so I gather the same.
We would renew our objection to that being included in the record on the basis he doesn't have standing to.
Okay, so you're objecting to the standing of the applicant. So we would let it in with that objection noted. I would point out that in Radnor Township there is, in order to oppose an application, a requirement that the protestant have standing, and not every Radnor resident can object to everything anywhere in the township and have that upheld in a court if one of our matters should go to court. The basic idea is that if your property is somehow impacted by a proposed development, then you have standing to appeal. But it has to be your property, and it's a case-by-case basis where, for example, I think you'd have to live closer to a property to be adversely impacted by a porch addition than you would to be adversely impacted by a 100,000 square foot shopping center. But at some point, you don't have standing, and standing is something that people may object to. We note it, it's preserved for the record, and should there be an appeal, you would preserve that motion. But again, just as a discussion, the law does not give standing to any taxpayer or anything like that. There has to be, your property is or where you live as a tenant or an owner has to be adversely impacted by the, potentially adversely impacted by the proposed development.
We have a couple of new. My name is Paul Bloomfield. This is Anthony Assetto. We have a few other items to add, including some new photographs, and maybe you can help me number these.
Can I ask a question, please, before
Sure.
you start? Just for my own knowledge. I went to the site a couple times when it was raining.
Okay.
Just to kind of look at what was really going on over there. I have a question. If I remember correctly, you can please correct me if I'm wrong. One of the reasons why you said that you wanted to put the parking lot on the south side as opposed to the north side, okay, behind the house, was because in case the water came or flood or anything, it would be more adverse for the children to be there as opposed to the other side, on the south side as opposed to the north side. I'm wondering, if it's raining, the children aren't outside. The children are now inside. So it would seem to me that you would want the parking lot where it'd be less apt to get flooded as opposed to more prone to flooding. So I would think that the parking lot being north, which would mean less, the chances of when people coming to pick up their children, they're not going to be underwater, as opposed, because the children
I'm
aren't
not sure
playing
if you have a
outside.
question, but in terms of handling the stormwater, by paving the only portion of the site that is elevated and able to perk that water, you're creating more runoff that's going to increase the
Yeah,
load
but
to the stream.
I understand that, but if the cars can't get there because it's underwater, now how are you going to get the children out of there?
Well, we have a backup
I mean,
plan for that.
that's a concern for me.
Well, the answer is through the back of the property to the adjacent bridge, but that's going to be handled just like any other weather-related emergency, like a snow day and so on. But I have a statement that was written in response to the community concerns that were sent in, and maybe I could read that into the record. We also have some new photographs and a revised plan that was developed after we were here last. We consulted with a landscape architect who made some recommendations that we've included and incorporated into the revised plan. So why don't we hand those out? Mr. Ryan, maybe you can help me number. Last time it was A7 was our landscape plan.
Okay, let me
So now
see
we have a
what I've got
revised
here.
landscape plan.
Kathy comes, she might be a little late.
Yeah. And these are dated, and there's a bubble there that shows the changes, so it should be clear which is the current proposed plan.
Yeah, actually, while we're at it, we should label the signed email from Mr.
Mr. Schneller.
Schneller as P1.
I think it's P2, actually.
Okay, we have the unsigned thing, which we
Thank
labeled
you.
it.
Well,
There was another from,
that one we marked as P2 from Ms. Minkazi and Mr. Wieland.
Oh, okay, yeah,
So this is P1.
okay, yeah.
So this revised site plan is A8? Is that right?
Mm-hmm.
and did you give them the photos?
Yes, I did. And the photos, how are we going to mark those? You want to mark them as a collection, A9? Or do you want to do each sheet? Do you have a preference?
I don't have a preference. No, let's mark them all as A9, that's fine.
Okay, collection is A9.
Okay, collection of photos is A9.
One,
So as I say, I have a statement that I'd like to just read into the record, if I may.
4.
Okay.
For the record, there are 4 sheets of photos.
So again, this is in response to the comments we got from the neighbors. Dear concerned neighbors, we at Mainline Montessori School appreciate the concerns you have expressed for the importance of protecting our natural resources. We share your concerns and support the goal of providing those kinds of protections. We understand the many benefits that riparian environments create and the need for protecting them. It is our position that the Township Code is unclear with respect to what kinds of improvements are allowed in riparian buffers, that the 35-foot required distance is arbitrary, and that it fails to offer any more than a minimal level of protection to the stream and its surroundings. The plan we have put forth was developed in conversation with the Township's engineer and was created by landscape design professionals. It provides substantial and meaningful improvements to reestablish an actual riparian environment. It includes the restoration of the stream banks through proper grading and supporting material. It also includes improvements to the bridge that will directly reduce erosion by providing an increased cross-section through which the water can flow more slowly. Further, it provides for the reintroduction of numerous trees, shrubs, and other plants that will create a stable and diverse riparian zone. Lastly, the location of the parking as proposed allows the elevated portion of the site to remain untouched, thereby minimizing runoff from the site and maximizing the site's ability to retain stormwater. We believe that this plan does far more than a minimum buffer to conserve and protect the environment and could serve as an example to educate property owners about these issues. Thank you.
Is that, do you want to submit that document into the record? Okay, this would be A10.
So I know we have some folks here who want to speak about the plan, and I know Mr. Malloy is here as well. I just have one other item that I would like to address, which is, again, just readdressing the question of structure and what sorts of structures it is that are allowed in these zones. And I'm referring to 280.89.6. This says permitted land disturbance in riparian buffer setbacks. And the first, section A, refers to detached accessory buildings and accessory structures, provided that a minimum of 10 feet is still remaining. It says that accessory structures would be allowed. If you look at the definition of accessory structures, that includes things like tennis courts and carports and so on. So anything that's underlying and supporting the principal structure. And certainly a driveway seems like it would fit that description, although not specifically described and nor specifically defined in the code to my mind. But again, I'm looking for a clarification as to whether or not a driveway would fit into this description of allowed permitted disturbance. So certainly if a carport is permitted, it's only natural that a driveway be attached and associated with that. So I'm not, maybe Mr. Malloy can help to answer this, or Mr. Ryan, but that's my immediate question. Otherwise, I will leave it to Tony Assetto, and we have with us tonight Jesse Forrester, who can speak to the plan as being proposed now. So,
Paul,
yes.
did you distribute this letter to all the neighbors?
No.
This is the first time you read it?
Yes,
over
it
here?
hasn't been distributed. I just
Because we want to see how they respond to your, improvement.
I understand. We got a couple of them at the last hearing, and I know that they had an opportunity to be here, and I know there may be some here tonight. So this is, our effort to address their concerns.
Thank you.
I'd like to talk to you about the revised planning plan, why we made some revisions since the last time we were here. Does this one?
Yeah.
This one does as well?
Yep,
All
it
right.
does.
There's Jesse as well.
Sorry, is that much clearer? Do they have my good side, Charles? I'd like to speak a little bit as to why this planting plan has been revised. Basically, after the last zoning hearing board meeting, we took this plant list and this planting plan to a licensed landscape architect, Jonathan Alderson and Associates in Wayne, to review the plan and to offer a comment. His comments basically, he approved of the plan with some conditions, and those conditions being to introduce even greater diversity than the original plan called for. So some of the quantities of the plants that are on the original plan have been reduced, but not numbers of plants. So different plant species have been introduced to fill that number, so we get proper coverage in each zone. There was some question about the potential of some plants to be invasive. And so the plant list was checked against invasive plant lists. And we feel like we've addressed that. So that's my introduction to this plant list. Jesse Forrester is representing Jonathan Alderson and Associates. He's a licensed landscape architect.
Well,
Sir, if you'll raise your right hand, I'll swear you in.
Okay.
You do solemnly swear or affirm this testimony you're about to give will be the truth and whole truth, nothing but the truth.
I do.
And state your full name for the record, please.
Jesse Forrester,
And spell Jesse
Jesse.
and Forrester.
Forrester, Forrester. And I represent Jonathan Alderson Landscape Architects is our company. I think Anthony summarized basically what we recommended to him, which was essentially to improve the diversity, include more native species that were typical of a riparian buffer zone, and they've done that. They've improved the plants in that way. So if there are questions.
Jesse, have you done this in another location with the same conditions?
I have done a riparian plan in Connecticut. I wasn't involved in the implementation, but I was involved in the permitting processes through DEP and with the Army Corps and all of that. So I have some experience, yeah.
They do approve the suggested plants and plantings?
Yeah, they were approved, yes.
and you're a licensed landscape architect in Pennsylvania?
Yes, that's correct.
Okay. Any other questions for Mr. Forrester? Okay, thank you.
I don't know that we have anything further to add at this point, so I
Okay.
know Mr. Malloy is here to maybe speak to that.
One question about the driveway. Did you ever think about a different paving, non-porous?
We've thought about
porous
it, and I know I've discussed this with Mr. Malloy, and his feeling on the subject, because of the floodplain location, was that having a surface that was easier to maintain is more important than having one that's pervious, because we're at the water table essentially here, so there's not much ability for this particular part of the site to perk or to incorporate stormwater at all. So it's not something we're opposed to, but it didn't seem to make sense given all of that. But talking to Mr. Malloy about it, that was his feeling especially. Knowing that the property next door has had a gravel parking area and gravel driveway, and that becomes a maintenance issue for them when they have heavy rain events that they're trucking in new stone and so forth. So it's a possibility that we're open to.
Okay. Anything else to add in your, okay? You want to move to have your materials made part of the record?
Yes.
Okay. Mr. Malloy, can we have your comment? Have you had a chance to take a look at this? Well, let's first have you sworn. My apologies.
Raise your right hand. You do solemnly swear or affirm this testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your name, please.
Daniel E. Malloy.
And Mr. Malloy, you're the township engineer.
That is correct.
Okay. Have you had a chance to take a look at this plan?
I have.
And can you give us your thoughts as to whether you think that it meets with the township requirements, et cetera?
Well, we have no specific requirements dealing with riparian buffers. The ordinance was designed to set aside a certain amount of land in order to plant a buffer, to reduce mowing, to plant the proper species of plants, to absorb nutrients, and try and do some stormwater quality rather than quantity. What I have seen and after meeting with the applicant, I looked at the Pennsylvania's Best Management Practices Manual, cross-checked some of the plants that were listed. Since I'm not real familiar with the plants, a number of them showed up in the recommended plant list from the Best Management Practices Manual. One of my comments when we met with the applicant was about trying to expand it, make it a little bit wider. There is a driveway on the one side that does limit how much they can plant there. They have a little bit more room on the street side. The applicant and the applicant's designer felt that what was proposed between the grasses and the shrubbery would make things better. And that's really where we came from when the whole driveway got rerouted in front of the building, was let's eliminate the lawn, let's try and plant a riparian buffer rather than just having grass, so that we do actually get some water quality treatment.
Okay. So I have two questions. Number one, do you think that what they've proposed adequately meets the goals that were intended to be served by the riparian buffer requirement?
Yes, I do.
Okay. And It sounded to me like, well, do you think that the proposal of having the driveway there in the riparian buffer is sort of offset by the amount of plantings that they're proposing between the driveway and the stream? Or better still, do you believe that the plantings that they're proposing between the driveway and the stream adequately addresses the runoff that will flow from the driveway towards the stream?
It is going to improve the quality of the water leaving the property.
Okay.
So what is going on now is the water's just running off the front yard and directly into the stream.
Right.
This is going to allow some of the sediment to be trapped and some of the nutrients to be trapped as well,
So even with the driveway,
I have a
this will
question.
be an
even
improvement.
with the driveway.
I have two questions. Prior to them doing construction, there was vegetation and everything there. So, I mean, they kind of cleared the area. So they kind of made their own problem in the fact that it's running off more now than it used to run off because they cleared it.
That's correct. I mean,
Right.
it was a lawn.
Right,
You
it
know,
was,
now
and
it's
it was trees. I
compacted
mean, you almost
and-
couldn't see the house. You almost couldn't see the house when you drove by there before. Now you can see it. So, I mean, they've kind of made their own problem there with clearing the land in front of the house. Okay. Also, you heard my suggestion. Do you think that it would be less evasive if they put the driveway straight through and then the parking lot on the northern part of the property, as opposed to bringing the driveway across the front, encroaching into the riparian buffer by 1,000 feet, and then putting the parking lot at the bottom part? Would that improve the situation?
Well, my question is, what are they going to put there instead of the driveway and the plantings that are?
It would
that are
still be the
shown?
plantings, and it would be grass where the driveway is now, I would assume.
That would be better,
Yes, that's what I thought. Okay,
but they have to put the plantings in.
yeah. They would have to put the plantings no matter what they did.
Well, the riparian buffer does not require plants. Our ordinance specifies a distance. And the goal is that we hope the residents who own the property plant it with the proper materials. But there's nothing in the ordinance that mandates the plants have to be planted.
And with this,
Did they say they were going to do anything when they came here the first time with plantings and buffer area? Do we know that?
I have the decision here. This is an appeal 2776. And the conditions they have to install and maintain stormwater management facilities to the as required by and to the satisfaction of the township engineer. That's you, Mr. Malloy. They have to comply with the requirements of Section 78, which is, just a second. They can't change the grade or alter the cross-section of the floodplain. This is, not the riparian area, but the floodplain, unless you're satisfied with that. They're supposed to give strong consideration to utilizing porous pavers in place of impervious surfaces where practicable, but that's not cast as an absolute requirement that they do that. And then they've got to put a deed restriction that says it's in a floodplain. I actually received that from just a little while ago from Nick Cornelia, and it looks like it's fine. That's just the statement that says it's in part of the property is in the floodplain. And those are the conditions. I think that what the board did approve in 2776 was the concept of a school where the access would come across that stream. So, and there was a map that showed what they were going to do, which I believe they've shown in the record, the original proposal and what
Right.
they plan to do now to alter it. So it seems to me that it's fair game for the special exception to address the revised access, but I think the concept that there's going to be access through the floodplain of some sort is, is embodied in the decision in Appeal 2776. And I have a copy if any board member wishes to look at it.
I have a question. Jim, you asked a question of Mr. Malloy a few minutes ago. can we read that question back and the answer? I wanted to make sure I understood what it was. Do you remember what your question was?
I asked two questions.
Yes.
The first question was whether or not, what has been proposed, in his opinion, adequately addresses the goals that were sought to be advanced by the riparian buffer requirement. And the answer to that was yes.
Yes.
Is that correct?
That is correct.
And I think the second question was, do the plantings that have been proposed adequately address the runoff that will be generated from
Okay.
the driveway?
I guess.
And I think the response to that was, well, the plantings are going to slow down the water runoff.
I guess I don't understand, maybe you can help me. I don't understand how, in looking at this plan, there's 1,000 square feet. There are 1,000 square feet intruding into the riparian buffer, which, as I look at it, eyeballing it, looks to be about a third of the riparian buffer area. Something in that neck of the woods. Does that look reasonable to anybody else? About a third of it? I don't understand how that much impervious surface intruding into an area can be offset by plantings that would
Well, I'm sorry.
that would eliminate the problem that the intrusion causes.
Well, we're talking about the plantings doing water quality benefit rather than quantity benefit. So while the thick plants are going to help slow the stormwater down, they're going to absorb a little bit, but their main purpose is a filter to try and trap sediment, trap nutrients, and let the plants absorb the nutrients so that the water entering the stream is better after the rainfall than what was there before. What I am referring to is what exists before the development started.
Okay.
You know, as Mr. Falcone pointed out, there were shrubberies in front of the house, but the area between the stream and the house was lawn.
Right.
So it is in a floodplain. The soils are very heavily clayed. There's a tremendous amount of water that runs off. Very little is absorbed because of the clays. So there's not a whole lot of difference in the water absorption between soils that are heavily clayed and blacktop. I mean, the majority is running off. So water quantity-wise, there is a little more water that's going to run off because of the blacktop. But the riparian buffer is about water quality. And that's why I answered the way I did, that I think that the plantings that they're proposing, even though there is blacktop there where there wasn't, is going to help clean the water that's entering the stream.
So
It's going to help, but it's not going to provide the same quality as if the driveway weren't there. Is that correct?
Well, the driveway being there is going to allow cars to drive over it, which they're going to leak oil, they're going to leak
Right.
gasoline. That's what cars do.
Right.
There's bits of rubber that come off the tires. If the driveway wasn't there and cars weren't using it, that would be better.
Thank you.
But is it safe to say that what they're proposing in terms of the net of what's been proposed is better than what was there before?
That's my belief.
Okay.
I couldn't give you a hard number saying I cannot say absolutely, but it's my belief that they're making an improvement.
And that's an improvement off the original lawn that was there before they graded. In other words, it seems to me the comparison is, as Mr. Falcone indicated.
There is an alternative which would be even better yet.
Yeah, but I'm just asking the question, is it better to have the original, is the planting with driveway a better overall thing than just simply a lawn and no planting?
I think the driveway with the plantings they're suggesting is better than just the lawn.
Okay. Anybody else have any questions for Mr. Malloy?
Dan, is it from your experience from other sites?
Well, we don't have a lot of experience with riparian buffers being planted this way. It is something that's relatively new. There have been a few jobs that were installed. I have no direct experience because no one has done any kind of monitoring before and after. But what I read in the journals, that's what I'm basing this on.
That's good. Thank you.
Any other members of the board? Mr. Bluefield?
The suggestion's been made that it would be better. Mr. Falcone is making the suggestion that the parking would be better served in the other location. The question is not whether or not we have a driveway at all. The question is where the driveway will go. So if the parking is relocated to the other location, the driveway would also be located to that location. There would be runoff from that side of the house just as much as there would be from this surface, correct?
Yes, there would.
So that runoff would still have to be handled the same way that this runoff is suggested to be handled. So the advantage of relocating the parking and relocating the impervious coverage is not as strong as Mr. Falcone is suggesting.
Well, I don't necessarily agree with that. I think if you take the square footage of the driveway that runs from north to south across the front of the property and did a straight shot behind the house and parked there, I think you have a lot less surface areas.
It's not true. We did lay it out, and the one problem is that you're on the extreme edge of the property, so that you're not able to have an aisle that has parking on both sides. So that lengthens the effective requirement for the aisle and lengthens the parking surface so that your total impervious coverage is the same. We actually found that this plan was about 30 square feet less of impervious coverage, which is almost the same, which we used when we widened this and that to make these turns a bit easier. But there's more impervious coverage when we laid it out to the other point.
You say that, I can't see that, but if you tell me, I believe you.
I'm glad. With your other point about the clearing that was done, there were 5 trees that were taken down that were along the Sproul Road that were within the line of sight. And there are 5 new trees that have been planted along the riparian buffer. So no clearing was done along the riparian buffer just to clear this. There's been some minor regrading being done for temporary parking and the sightlines that had to be achieved. That was done in a plan that was approved by the Shade Tree Commission, and those new shade trees have been placed along the riparian buffer where hopefully they will help to do some good for the stream and not just make it harder to see the property, but actually provide some shade. Mr. Malloy, the front of the property is a good example of a buffer. We have the street and about 100 feet between the street and the stream, and it's flat and lawn. And your impressions of the riparian quality of that side of the street?
Currently?
Yes.
Well, I mean, there's minimal benefit. I mean, that water, the grass is doing very little to absorb
So even though
anything.
the number, the 35-foot number, is more than met on that side, the protection is not provided there
That's right,
because of the lack of proper grading and proper plantings, et cetera.
the proper plantings.
So that same thinking applied to the other side, even if there's an encroachment, with those other benefits of having the right kinds of grading and plantings and so forth, we can expect to improve the conditions there.
Yes, I believe there will be an improvement because of what you're planning. I mean, certainly the wider, the better.
Lastly, we've got the back corner of the site, which is the only portion of the site that's not in the floodplain. What would be the impact of paving that?
This is where the playground is?
The back
where
corner of the site, yes. Which Mr. Falcone is suggesting is a better location for the parking. Okay. We're trying to share the mic, I'm sorry. So the implication of paving the back corner of the site that's currently out of the floodplain.
Well, generally, the higher the ground, the better the percolation. So I don't recall what the soils are in that back corner, but the further away from the stream you are and the higher you are.
You may remember, we did do some perk testing there, and
Yes.
that location was found to be able to perk
Right.
to some extent.
Thank you, that's right. So not paving that is better. It allows the water to naturally be absorbed by the ground rather than paving in an area where there's poor percolation.
Okay, thank you. The only other question I have is, again, with respect to accessory structures, does a driveway qualify as an accessory structure to the underlying use?
Well, driveway is not an accessory structure.
Is
I
it
mean,
because it's
where
not
I
a
was coming
structure?
from was item G,
Mhm.
where it talks about temporary construction attended to construction activities occurring within the riparian buffer setback, provided, however, that such temporary construction shall be removed and any land disturbance within the riparian buffer setback be remedied within a time period approved by the township.
And-
So I was coming off of the land disturbance.
Okay, but under A here, where we're talking about disturbances that are permitted, it allows accessory structures such as carports. So does not that imply that a driveway would be an allowed improvement to that portion of the site.
I'm not sure.
Well, that's why we're here.
Well, that's why they're here.
Okay, thank you.
Okay. Any other questions?
I have a question. I still have a problem with the intrusion of 1,000 square feet representing about a third of the riparian buffer. I can't get past that yet.
The riparian buffer, for one thing, is on both sides, so
I understand
it's not
that.
a third, it's,
Well, okay, but a third of this side of the stream bed. And I have a problem with that. Separate from that, I still have a question. I don't understand how running the driveway on the north side of the building and putting the parking there, I can't comprehend how that is the same square footage of impervious coverage as going all the way across the property. I just don't understand that. I'm not sure that'll get me past my problem, but
can you see this plan that was, this is the plan that was presented when we first made our appeal, and this shows the existing structure. There is a deck behind there, and the only way we can do this is to have the driveway continue past the house, or past the school, and past that deck, and we would probably need to maintain some small buffer there, but again, since this is on the left side of the extreme left edge of the property, there's not an opportunity to park on both sides of that aisle, so that the parking would either have to turn or either make a 90-degree turn or a zigzag to allow for parking on both sides of an aisle, or simply extend it further. And so instead of having 10 spaces on each side, let's say, we'd have 20 spaces along an aisle. So it's a longer, we did lay this out, and it is longer driveway. You can see that the one side of the house is closer to the street and closer to the stream than the other. So by moving to the other side, we were already lengthening that effective driveway even before we passed the house. And we have to pass the house by another 16 feet minimum to get around this deck. So there's an extra 30 feet or so of length, plus the parking area that has to be longer because of the nature of the access. So it is. And it puts us squarely into, the corner of the site that is the floodplain. And just, not in terms of the operation of the school, but just in terms of stormwater management, this is not a good solution to put paving on the only portion of the site that's not in the floodplain. During a severe storm event, the rest of these surfaces are potentially underwater, part of the stream bed. So the surface itself, whether it's pavement or lawn, really is immaterial if it's underwater. But to pave the only portion that's typically not underwater is certainly causing runoff and limiting the ability of that portion of the site to handle stormwater that's running off from the hill, from the highway that's behind here. So,
Do we know what the perk, forgive me, I don't know what value we put on the ability of soils to perk, whatever metric that is, but what's the difference in the runoff coefficient, I think it is, between what we've got there now with respect to clay soils and what's proposed, the blacktop? I mean, what's the difference in terms of being able to handle the water?
I don't know a number, but certainly up to that flood point, we have two different types of soil on the site. So there's a loam that can perk somewhat at the back corner.
Right.
The rest of it is a very silty clay soil
Right.
that tends not to perk at all, and the water table is quite high anyway, so even if it could, there's a very limited window for having the ability to perk, and during bad stormwater events, that gets reduced because that water table is coming up. So as sites go, this one is about as poor as any in terms of being able to absorb that stormwater. So it's got the most runoff coefficient that it could have because of its location in the floodplain.
Okay.
Paul, do you have plans, maintenance plan?
Not at this point, but in talking to the landscape architect and the landscape designer, I think that would be implemented as we go here and become something that the school would participate in on an annual or biannual basis.
Okay. What about the total number of parking space compared to the 2776 application and this one?
We actually have, I think, one or two less, and the original information was included at our last hearing.
Okay.
We meet the minimum requirement, but we've reduced by one or two, I think, since our initial application.
Okay. I'm sorry I wasn't here. That's why I asked.
Yeah.
Thank you.
Okay. Anything else?
No, I don't think so.
Board have any other questions or comments for the applicant? Would any members of the audience like to make any comment? Sir, if you'd identify yourself and be sworn.
I'm John Nagel. I'm here tonight as the Executive Director of the Radnor Conservancy.
If you raise your right hand, do you promise to tell the truth, the whole truth, nothing but the truth?
I do. As I said, I'm here tonight as the Executive Director of Radnor Conservancy, and part of our mission is the maintenance of the quality of the wilderness, woodlands, wetlands, and those types of things within Radnor, in addition to the open space, obviously. We worked with Darby Creek Valley Association to review the plans that were given to you at the last meeting, not the current set of plans. And with me tonight is Jamie Anderson, and she's reviewed those plans and also had an opportunity to briefly sit with the applicant prior to this meeting. Jamie works with Darby Creek Valley Association. She's a former watershed specialist with the Conservation District in Delaware County. And Darby Creek Valley Association has a program called Backyard Habitats, and it's really about riparian buffers and stream quality and that kind of thing, and she's their technical expert for that. One of the things we note as we reviewed this was that this is probably the first appeal you've had against the new riparian buffer ordinance. And as such, whatever we do tonight is potentially setting precedents for the future, so we were very sensitive to that. And the one thing we note is we really do applaud the applicant for what is a very creative solution, we believe. The riparian buffer ordinance was started to be kicked around by the EAC years ago when I was a member of the EAC, probably 10, 12 years ago.
Can you just tell us what the EAC is?
The Environmental Advisory Committee here in Radnor.
Thank you.
In fact, the statement was made earlier about 35 feet being arbitrary, and in fact, good practice is more like 100 feet. So, and the EAC they were the drivers for this ordinance, and in order to get it passed, they had to actually downgrade the ordinance significantly from what is considered a best practice. The goal of the riparian buffer, of course, as Dan was mentioning, is to slow the flow of the water and to absorb nutrients so that the water entering the stream is of higher quality than it would be if you didn't have a good buffer. And what they've done with their plan is, I relate it most to, I'm sure you're familiar with wetlands. And if there's currently understanding that you can fill wetlands as long as you replace them with equal or better quality wetlands. And this is an approach that's very similar to that in my mind, in that they're planting over and above what the ordinance normally would preserve if they were not encroaching on the buffer. And as such, we strongly support the approval of this appeal. Now, Jamie has some comments, and we would like to condition our support on just resolution of her comments with the applicant.
Okay.
Hi, I'm Jamie Anderson.
Raise your right hand, do you promise to tell the truth, the whole truth, nothing but the truth?
I do.
And state your full name, please.
Jamie Anderson, Jamieanderson. Hi.
Ma'am, before you start, why don't you give us a little background on your professional experience?
Okay. I'm here as a representative from the Darby Creek Valley Association, which is the local watershed group, and I think Creek is a tributary to the Darby Creek. Sorry. Okay. And so they asked me to review the plans because Rob and Mann had done that because they were concerned about the impact of to the riparian buffer and to the creek overall.
Wait 1 second. Are you a professional engineer in the state of Pennsylvania?
No, I'm not.
Can you describe for us your professional qualifications?
Oh, okay. I have worked in the environmental field. I was the watershed specialist for the County Conservation District, so I have background in environmental science and sort of the ecological habitat function of riparian buffers.
Okay.
But not the engineering of them.
Okay.
Okay, yeah. Right now I teach at Widener in environmental science, and I do some work for Darby Creek on the side as well.
Okay.
Okay. So I understand the concern with putting so much impervious surface in the riparian buffer. It is kind of, counterintuitive to what we're trying to do for creeks and for the environment. But the way it stands now, I had a chance to drive by the site on my way up here. There's not much benefit to what's going on in the buffer at this point, being mown lawn. They said it was shrubs before. John had said that was multiflora rose, which is a very invasive species. Not much benefit overall to habitat and to the creek as well. So if there's a way to kind of get a buffer put in and to sort of stabilize the stream banks, you can tell from the pictures the banks are very, very terribly eroded. They're actively eroding. That's causing sedimentation to the creek, which is flushing down into Darby Creek as well. And so it's just sort of poor quality, poor stream quality as it is. So anything that can be done to stabilize those stream banks and put any kind of plantings and buffer in there to sort of stop the erosion and improve the overall habitat and ecology of the creek would be beneficial. Some of the plants they've chosen from the plan I saw, I guess was more of, a landscape plan for maybe your yard and not sort of a habitat type plan. Some of them were sort of questionable whether they were invasive or not. A lot of them weren't native. When you're putting in a riparian buffer, you really want to focus on putting in native species, those that, will create the habitat that are, sort of have evolved to grow here and live here. And so you want to avoid non-native species and anything that's invasive. I do think that they need to have some sort of maintenance plan. If there was multi-floor rows there in the past, it's really hard to get rid of. And if you're not monitoring what you've put in there, even if you plant plants in there and you put some sort of seeding in there, it's going to keep coming back. And so you have to continually go out there and pull the invasives and maybe spray them if necessary and really make sure they don't take over what you've just put in. My only other concern was right along where they're going to put the driveway, they had said that was going to be mown turf grass. If they're going to put this into the riparian buffer, I can understand maybe mowing a foot or two for maybe some sort of safety sake, but why they can't let that grow up as a meadow to sort of intercept more of that water would be more beneficial than just having turf grass there.
Any members of the board have any questions for Ms. Anderson?
You mentioned the way the scenario that exists at the present time.
Mm-hmm.
And you refer to that and then you use the word erosion. So left as it is,
Right.
would a great deal of erosion be likely to occur?
Yes.
So something has to be done to prevent erosion, whether there's a driveway or not. Is that correct?
Yeah, but I don't know there's any sort of legal standing to make them do
I
anything
understand
about
that, but as a
right.
property owner protecting their
Right.
property,
You would think that someone
You
would
would
want to do
think.
something to stop the erosion, yes, because it's going to
Okay.
keep cutting their property and washing their property downstream. Yeah.
Any other questions or comments? Okay. All right. Anyone else in the audience have any comments they'd like to make? All right. Let's see here. Well, I guess I'll take this one, and we'll hear from everybody else. The applicant has sought a special exception from section 280-89.7, boundary determination. It is my opinion that we should grant the special exception, and I base that on my conclusion that, and as testified to by representatives of the Darby Creek Association and the Radnor Conservancy, what's been proposed is far and away an improvement over what exists now. My understanding of the testimony was that the driveway that's been proposed is only marginally worse in terms of runoff than the mown grass that exists there now. And so, again, I think what has been proposed is a net benefit to the township, to the state of the stream, and I think a special exception is warranted and appropriate. Kathy?
I agree.
Charlie?
I disagree. I just can't.
Mike.
I'm sorry. I just can't. I don't feel good the fact that the driveways, so much of the drive or impervious area is in the buffer. I also have a hard time with applicants who propose one thing to this board and then come in after the fact and want something totally different. I'm not so sure that I would have agreed to this back originally had I seen this plan as it stands today. And I still believe that there's a better way of doing this. Everybody keeps saying what's there now. That's not what was there when they started. I think part of the problem with as you saw it, you said you went to see it today for the first time, wasn't there before they started doing this. So it's not a real good judge as to what what should be. And I kind of believed when they talked about this before that they were going to put some things in plantings to make it nicer in front and stop the erosion, because that was one of our issues back in the original. So I have to vote against this.
Okay. Peter?
I'm opposed. I think it's admirable, the plantings that are being proposed. I think to a great degree, some of that's needed anyway to protect the property. I just don't believe that allowing this much intrusion into the riparian buffer would, I couldn't feel comfortable being a steward of what I believe is the intention of the code.
Okay. Cora?
Yeah, Jim, I have to go with what you have explained, mainly because, I see that the township engineer has evaluated the situation and said it is going to improve the water quality, though not quantity. And as far as the applicant's, request, as long as they maintain these plans on a long-term basis, it should be as a condition, I would support.
Okay.
Yep.
I think actually a little clarification on what we're approving. Are we approving the new planting scheme with an obligation to maintain? Are we, is the board interested in considering comments from the Conservancy and the Darby Creek? I guess I'm a little uncertain as to what exactly. I assume we're approving the new plan, because that was the new land riparian planning plan that came in as
Right.
Exhibit A8. Is that, in terms of writing this, is that adequate to approve
Well,
A8?
Do we, excuse me, Mr. Malloy, does the township require maintenance plans for this sort of thing? Or any sort of analogous improvement?
Our typical language when we approve a land development is to install and maintain the plantings. So that is something that we did not do before, and we did have a problem where they installed them, they died, and they took them out. So install and maintain.
Install and maintain.
So is there any way you can put a condition that they will put some money set aside for maintaining for
I think
number
that's
of years?
more than, I think what would happen if they don't maintain it, they'd get cited.
They get a code
They'd get a
enforcement
cite-
violation.
Code enforcement, I think that's the way would be better, more likely.
Yeah, if we
By
had a
the time they-
plan,
yeah.
if we had a plan, we knew what they started with, we knew that this is what had to be maintained. That would go a long way.
Sounds like an awful lot of work on the part of the township to go around to sites and check and make sure plantings are being maintained correctly.
Well, I would agree with that, with the condition that it be maintained.
Yeah, so install and maintain the A8 planning scheme?
Yeah. Yeah, you okay with that, Kathy?
Yes.
Okay. Any other questions, John? Okay, very good. It's granted. The next matter is appeal number 2816, Richard Mattis, lessee of property owned by Michael Civitella, located at 200 Plant Avenue, Wayne, PA, zoned C3, Service Commercial District and in Ward 1. Applicant seeks a special exception to operate a wholesale coffee roasting business at 200 Plant Avenue, Wayne, PA. Sir? If you'd identify yourself?
Yes. I do. Full name is J. Richard Mattis, Richard Mattis.
Oh, special exception to...
And I have something that I was supposed to put in the application, permission to use the space and from the landlord, and also...
Yeah,
Okay.
Sorry.
I was asked to bring permission from the landlord, and I have that here. And also, I was asked to bring a plan with bounds and meets, and that I have as well. So may I bring these up to you guys?
Sure. And you're seeking a special exception pursuant to what code section? 28055D?
Yes.
All right. If you could bring that up, yeah. And before you start, what we'll do is we'll walk through and mark your exhibits. Because it doesn't say coffee roastery. Well, he's actually, it's more of a manufacturing operation, I think.
Yes.
Okay, before we start, let's walk through your exhibits.
Okay.
We'll make your application A1. And you have an overhead photo?
Yes.
We'll make that A2. And you have some streetscape photos. This one will make A3.
Right.
A4.
Okay.
A5. This one's A6. A7. A8. A9. Looks like a picture of the roof. A10.
Yes.
Looks like a neighbor. A11.
Mr. Chairman,
Yep.
I have to say, we don't have the owner here. I don't think that this document is a lease. It says a proposal to lease. It is, I mean, to me, a lease is something that is a document that, among other things, gives a tenant the right to seek zoning approval. And I don't see a lease here. And we don't have a, in the absence of that, we'd require a power of attorney if somebody's going to represent the landowner. I'm not, I think we have to consider this as to whether this is enough to start a hearing.
Couldn't it be construed as a written option to lease? And if that, a conditional option, conditional on approval of the...
It says a portion, doesn't say what it is. The other thing is the plot plan, I don't, you know, it doesn't describe it doesn't identify the premises. The plot plan doesn't tell you how much parking there is. I mean, it's thin. It's very thin.
Okay.
The other thing is, I think,
Well, we're just here on the use issue, not as relates to parking or anything like that, right?
well, I guess,
But if it's a change of use, don't we need to look at parking?
You're right.
yeah, I mean, it would be rather aberrant to give a, I mean, I think one of the things is what is this use? My understanding is the applicant would take the position that it's a wholesale business establishment, which would be permitted of right. If not, it would go into one of these special exception uses. I guess, you know, if we decide there's no, that it's a use that's permitted of right, the board decides that it's a use of permitted of right, that just simply says that the use is permitted there, and they would have to satisfy all applicable parking on their own. It would be very akin to the Owens Lane a street decision that the board reached. But in terms of, you know, status of being there, and I'm not trying to, you know, gratuitously throw monkey wrenches, if in the absence of a signed lease that identifies the premises and authorizes the tenant to seek zoning approval, Either the owner ought to be here or there ought to be a power of attorney. And I think we've got something that is neither a lease that authorizes the tenant to seek zoning approval, nor is it a power of attorney or authorization from the owner. Or arguably, it's again, it's up for the board to decide, but it's, I'd have to be candid, I'd like to see a little more.
We usually have had the owners here in these situations. So I think we need to have the owner here or power of attorney, I agree.
Okay.
I agree.
Okay. But I'm sorry to say that we're uncomfortable moving forward without something more substantial than this.
Yeah. Okay, yeah, he thought this would be enough because we talked about it. He's working on a lease for me, and
And my apologies.
all right.
So you have to ask if you were to continue the hearing, that you also grant us an extension to hear the case till the next hearing while you get this stuff in, because otherwise, you'd have to reject the appeal totally. We don't want to do that.
I'm sorry.
What we need to do, what we will need, Mr. Mattis, is you're agreeing on the record to extend our period of time for conducting the hearing till the next hearing and then
I
making
agree.
a decision thereafter.
Yes. I agree. Now, will a lease do, or must you have him here in person?
Well, I think there are a number of things. You could have a signed lease,
And that would be
if you
fine.
get that far. You
Okay.
could have a power of attorney to, testify on behalf of the landlord, or you could have the landlord here. And I think
Okay.
those, we have on our, I believe, Bob, don't we have on our website a form of power of attorney that shows what we need to be able to do?
Yes, we have that form available.
But if you get a signed lease, you probably should make sure it's contingent upon getting zoning approval.
Yeah.
Right.
And the lease also should authorize you to get zoning approval. In other words, you put
That'd
something
be-
into the lease that says that if you don't get the zoning approval, you can get out of it. That's just for your own personal protection, but also that you're authorized to apply for whatever zoning or other township approvals you need to conduct your use.
Right. He thought that was this.
The other thing, and it's up, it seems to me that you either have, as you've presented your application, a use that's permitted of right, in which case we say that coffee roasting is a use that falls within Section D. That doesn't say anything more than you can, roast coffee beans there.
Perfect.
It doesn't say that your parking is okay or so forth. If you need a special exception, then we actually need all that detail about
Right.
parking. So in order to grant a special exception, we'll need more of a plan than this. We'll need a plan that shows, your square footage, your number of parking spaces, and so forth, because if we get into a special exception, then we do have to address the underlying dimensional requirements, the parking and so forth. You might, even want to consider securing counsel to help you in this. Unfortunately, zoning is, it's its own set of rules. It's not something that sort of follows naturally like many other things in life do. And unfortunately, this board is charged with enforcing, the rules and granting relief where appropriate, and part of that is having the authority for you to be here and also understanding what we're doing.
Okay. May I ask a question?
Absolutely.
Would it make sense for me to reapply as what was the word, right, that I have a right to use this? Because, it seems that it is granted there, just nobody's ever written coffee roasting in the zoning board. Because
To be honest, that's a strategic question. If you go that way and we say no, then your application doesn't give you another way to get what you want. If you plead in the alternative, if you say, I'm permitted as of right, and also, by the way, if I'm not, then I get a special exception,
okay.
and you have two avenues to get the relief you want.
Okay.
Yeah, you can apply in the alternative. I'm entitled to do it without approval, or I would like to get the special
Right.
exception approval. And again, counsel would help you with that.
Okay.
Yeah.
And that's a matter of phrasing And I have to write it the right way? Is that?
There's no, it's not that there's magic language, so to speak, but there are two ways to get what you need
Okay.
under the zoning code. One is you're allowed to do it, and you just need to get our say-so that we agree with your interpretation, or that you fulfill the requirements of the special exception
Okay.
to permit you to do it.
And for that, for the special exception, I have to have things like parking.
Yeah, you have to make a case, so you'll need exhibits and the
Okay.
like.
And also, I would suggest that you have to have a plan of each equipment, where will it be placed within that space.
Okay.
And
You-
you talk about the, gas line and all those things.
Right.
Where is it? Is it outside or inside? All those things
Right.
would help.
Okay.
Okay.
Well, thank you for your time.
Sure.
Okay. We'll see you again.
next week.
See you next time.
Oh, sorry, next month.
And you'll end up being first. You'll go first.
Okay.
Yeah.
Okay. Thank you.
Yep. All right. The next matter we'll consider is appeal number 2817, Cam Lacey representing Scott and Connie Enoch, owners of property located at 230 Poplar Avenue, Wayne, PA, zoned R3, residential in Ward 1. Applicant seeks a special exception from section 28025D1 for side yard setbacks. Property is non-conforming with regard to side yard setbacks. Mr. Lacey.
Jim, I think it's 281 on 1B1.
I have no doubt.
Did I misquote the, sorry,
It's easier, the new one's easier.
okay.
I'd like to, we have a power of attorney from the owners for Mr. Lacey, so, and it's our township form of power, so that's in order.
Okay.
Mr. Lacey, I'll swear you in. Do you solemnly swear or affirm the testimony you're about to give is the truth and nothing but the truth?
Yes, I do.
And say it.
It's Cam, C-A-M, Lacey, L-A-C-Y.
Mr. Lacey, do you want to walk through your exhibits and mark them before we get going? Or do you want to do it as you
Some
make
of
your
them are marked.
presentation?
We could probably talk about them as we go.
Okay. Well, let's,
Is
Go ahead,
everything,
John.
are they, actually have Exhibit A's and so forth
No.
on them?
mine do not.
Probably not the
Mine
way
do
you
not.
like to do them, John, but
Pardon me?
probably not the way you like to do them, but.
All right, well, let's do them the way we like to do them.
Okay.
So we'll make
How about the application is A1?
A1.
Okay.
Deed is A2. Power of attorney would be A3.
Okay. I don't think I have a copy of that in my file.
I have it if you,
Okay.
I mean, I've looked at it, it's fine.
Yep.
Okay. We have a, this is, I guess, the existing plan here.
Is that on the 8.5 by 11 sheet?
Yeah,
or
the 8.5 by 14 sheet. Actually,
These two sheets, we can label these, about the existing as A4,
okay.
and then the proposed site plan can be A5.
Okay.
And those would be the
Then you have
legal
a photo
size.
key, which would be A6. There's a,
Oh, yeah, that's the photographic key, A6. And then the photographs are actually labeled P1, P2, P3 in that package.
I would recommend labeling the photographs as you have A, B, C, and D, make them A7, because P is usually for the protestants.
Oh, really? Okay. So we're going to go A7 through whatever?
Yeah, just A7 for all three of those pages, and you'd have A7A, A7B, A7C,
Okay.
and all of that good stuff.
A7C.
Okay.
Okay. This is a house on Poplar Avenue in the R3 section. It's also in the North Wayne Historic District. And the proposed work is, there are two things we're really doing. There's an addition off the back of the building, and as you can see in the existing
plan, the building envelope or setbacks cut into the building itself, so the side yards are both non-conforming. The rear, the front are fine, and all the impervious cover and building percentages are fine as well.
Okay.
I'll just move this closer. In the proposed work, we're going to fill in this area, which will encroach into the side yard about 3'4". Will not go any further than the main body of the house. It's not as far as this little bow window that's on the side. This area here is a deck, and that will be within the confines of the setbacks. The front portion of the house, there's an area here where we're going to restore a front porch. This is one of maybe 6 or 7 on this street that was of the same design, built in about 1905, that had a front porch along the whole front of the house. And in 1957, this was removed and this was enclosed. The owner now wants to rework some of the interior of this portion here and add a front porch back onto that. This plan has been before the Historical Architectural Review Board and approved, and the commissioners have approved. That's part of it as well. So that was done the first weekend of this month. I also have this set of pictures, which if you go to A7A, which has A, B, and C, B is the house that we're talking about. A is directly north of that, and C is directly south. And you can see they're similar designs, more so the C one. That's kind of what this used to look like. This has a stone base of the pillars, and this one did not. But the idea that there was a front porch across the whole front of the house is what this house used to be. Side yards are on A7B and a little bit of the rear. Some of the rear gardening on A7C. And then this is a shot of the rear of the house from down in the yard. It's extremely thick gardens on this property, so it's kind of hard to get a good view. I also have some information that was part of the HARB submission that would probably be a little more explanation on the various houses that are in the neighborhood, if I can hand them out.
Sure. We'll make this entire packet A8. Thanks.
This first page on A8, it describes the North Wayne Historic District and where the property is located. It's right on the edge in this location here. This is the existing front of the building, and a little section of the from the building inventory from the North Wayne Historic District describes this property. And it described it as having a front porch going all the way across. So this is the area right here that would be infilling on the front. And then the other photographs are that entire streetscape, which shows that I think there are only 3 properties that do not have front porches. This being one of them, which it used to have, actually. So, and this one was done. Actually, this was one that was redone not too long ago that had introduced a porch. There's also, and this one's called A2, but we're going to have to call it A9, I guess. Or is this part of A8? This is part of A8. These are some quick sketches of what this addition, what these additions would look like.
The front elevation shows this part of the porch being added, and the rear additions are here. And from the side, they're, one-story small sheds, this being here. This roof line exists as it is now. So really the two pieces that we're trying to add, they encroach on either side of the side yard setbacks, but they do not go any further than the existing house.
Okay.
And I'll go back to A5 to show how that works. The other thing I have I have 4 letters that are from neighbors to either side of this property owner, and 2 across the street, directly across the street, which you want to just call them A9, or we're at A10?
You could say 9.
A9, okay.
Yeah, that's right.
I only have one copy of that.
Okay.
And these are all letters of support?
This was they're the exact same letter that was given to each property owner, and they were given a site plan and these elevation sketches so that they could review the plan, and they've indicated that they've approved everything. I think that's everything I can think of that describes the project.
Okay. Do any members of the board have any questions or comments? Any members of the audience have any comments or questions? Okay. Would you like to move to have your exhibits made part of the record?
Yes.
Okay. Kathy, you want to take this one?
I would suggest that we grant this under 280-101B1 because it is not expanding beyond, is this the right section here, 280-25?
No, I think it's a 281-1B1.
Yeah, that's what I thought.
Clearly
Yeah.
101B1.
So the 280-101B1, because it is not expanding beyond the original property, the building that is there.
Right. Charlie?
I agree.
Peter?
I agree.
Cora? I agree as well. It's granted. Thank you.
Thank you all.
We're adjourned.